Good morning. We're hearing on case 1CA CV150745 entitled Rochon versus Grant. Each side will have 20 minutes to present their argument. Opponent, you may save as much time for rebuttal as you wish, but you must keep track of the time yourself. We have a clock at the podium for you. We're recording the argument, and the argument should be up on YouTube in a couple of days. If you want to watch how you did it, you're certainly welcome to do that. Because we're recording the argument, when you come to the podium, please identify your client and yourself so that we can keep everything straight. We've read the briefs and the record. We've conferenced the case before argument today, so we're familiar with the arguments and the facts. So when you begin the argument, just start with what you'd like for us to know. Counsel, you may begin.
Good morning. Thank you to the panel. I'm Robert Weeks. I represent the plaintiff, Jamie Rochon. I would like to reserve 5 minutes for rebuttal, please. The plaintiff appeals the dismissal of her claim for punitive damages on a judgment as a matter of law. The defendant, a licensed healthcare provider, set up a computer program to falsify all of his medical records for all of his patients for literally 4 years straight, in violation of both legal and ethical guidelines. As a result, the defendant's records did not even mention that the plaintiff has titanium rods inserted along her spine, which is extremely important since an adjustment over the rods can cause serious physical injury.
Doesn't Dr. Grant contend, or didn't he testify that on his computer screen the x-rays themselves are displayed as part of the patient record while he's seeing the patient?
Yes, Your Honor, that is correct. I think that there's a slight difference between the medical records as a whole and this screen that popped up. So the screen that popped up did include small pictures of x-rays at the bottom of the screen, but the top of the screen also contained incorrect information that was fed in through the records. So it contained the x-rays at the bottom, but the top of the screen misidentified where the rods were located and also indicated that at the top of the screen that her regular adjustment would have been an adjustment that was right over the rods.
But if the x-rays are on the screen as well, isn't that obvious?
Well, it would depend, I guess, on how careful the defendant was being in looking at the screen prior to adjusting the plaintiff. So if he was looking at the x-rays, then perhaps he would have known that the rods were there, but that doesn't explain why he adjusted over the rods. I mean, it has been established that he did, in fact, injure the plaintiff by adjusting over the rod, so one would assume that prior to adjusting her, he did not notice the screen, the x-rays at the bottom of that screen. It's more likely that he looked at the misinformation that was at the top of the screen that told him to adjust right over the rods.
Why isn't that simply negligence or departure from the standard of care as opposed to the more heightened standard for punitive damages?
Well, it is a breach of the standard of care, but for punitive damages, part of the basis for punitive damages is that the defendant engaged in a pattern or practice of conduct prior to causing the injury that demonstrated that he was consciously exposing the plaintiff to an unjustified risk of harm. And since plaintiff can prove punitive damages in that way, and we were trying to prove punitive damages, the fact that he had this long history of violating ethical guidelines demonstrated that he was consciously exposing the plaintiff to an unjustified risk.
So your theory is that maintaining this system whereby incorrect information is automatically populated into each chart note is evidence of this pattern?
Correct, Your Honor. The harm that was risked by the defendant's consistent pattern of recklessness actually occurred because he did, in fact, end up performing an adjustment over the rods, just as his records indicate that he had done on every previous treatment. Plaintiff's expert confirmed that actually adjusting over the rods is in fact a breach of the standard of care that caused the plaintiff injury. But the claim for punitive damages was not based on the fact that the errors in the records directly caused the plaintiff harm. There's no way that the errors in the records can directly cause the plaintiff harm. I mean, they're inanimate objects. The only way that they can cause harm is if a person relies on them and based on that incorrect information then causes injury. So the plaintiff's claim for punitive damages in this case was dismissed solely because the plaintiff's expert did not identify the errors in the records as a direct cause of harm. But again, that wasn't the basis of the plaintiff's claim. The issue is not that the records caused harm, but that they're a demonstration of the defendant's prior conduct that exposed the plaintiff to the risk of this accident occurring. It's important that there's no actual case law that the defendant has produced that requires expert testimony to send a claim of punitive damages to the jury. So this would be a case of first impression where the defendant is asking the court to create a heightened standard for medical malpractice cases where it doesn't already exist. And this case was actually tried or litigated for over a year in front of Judge Herod. And Judge Herod had rejected this argument from the defendant twice and indicated twice that the plaintiff's claim for punitive damages could proceed to the jury without this expert testimony that the defendant is demanding. It's only when the case was switched to Judge Blomo for trial that the defendant found a more receptive audience for this argument, and Judge Blomo ended up dismissing it solely because of this lack of expert testimony that there's no legal support for. I think the principal error that the defendant's argument makes is that punitive damages are not based on conduct, they're based on state of mind. So the defendant's brief argues over and over again that the plaintiff failed to causally connect this conduct to injury. It repeatedly argues conduct, but the state of Arizona has rejected that as the basis for punitive damages. Under Arizona law, punitive damages are always based on the defendant's state of mind, and conduct is relevant only to the extent that it is circumstantial evidence of state of mind. So the causal connection that is required, and plaintiff acknowledges that there is a causal connection that's required between the state of mind and the eventual injury, but it's not between the conduct and the injury. Because state of mind can be proved through an entire cornucopia of different circumstances. And so to allege that each of those would be required to be the cause of the injury is not realistic.
So what is the connection between this alleged state of mind and the injury here?
Well, the connection would be that he acknowledges to looking at the incorrect records immediately prior to making the adjustment. And the mistake that he made that injured the plaintiff is exactly the same as the injury that is in the records. So that is clearly a causal connection that the jury could be able to make for itself. And because it's an issue of state of mind as opposed to conduct, it's not an issue that expert witnesses are allowed to testify on. Basically, the issue is, did the defendant look at these records prior to making this adjustment? And based on looking at the records, he believed that he was supposed to adjust on this particular place. But that goes to an issue of the defendant's state of mind. It's not something that a chiropractic expert would have any insight into. It's also possible that he didn't check any records at all and was just going based on his memory, in which case the errors in the records wouldn't have contributed, but the lack of checking the records would have. The defendant relies on two cases, Forker and Salcedo. And both of these cases do contain language when viewed in isolation that supports the defendant's position, but the defendant doesn't account for the other language in Forker and Salcedo. For instance, in Forker, the court held explicitly that conduct that occurs after the injury has already happened, which plainly could not have caused the accident, can be used as the basis for punitive damages. So there is no requirement that the conduct that's used as evidence for state of mind for the purposes of punitive damages be the cause of the injury. Forker states explicitly that the conduct only needs to have a reasonable relationship to the state of mind that existed at the time of injury. And since Forker makes it clear that after occurring conduct can be the basis of punitive damages, that pretty much alone defeats the defendant's argument that conduct must be the cause of the injury to be relevant to punitive damages. Again, in Salcedo, the court says explicitly that the requisite intent and conduct only needs to occur in tandem with the conduct that causes injury. So the quote in Saucedo, which explicitly acknowledges that the conduct that serves as evidence of state of mind for punitive damages only needs to occur in tandem with the conduct that causes injury, that presupposes that the conduct that causes injury and the basis for punitive damages might be two different things. And even if expert testimony were required here, in this case, the plaintiff's expert testified that it was in fact possible that these errors in the records contributed to the eventual injury. Again, the defendant or the plaintiff's expert testified that the injury was caused by the defendant physically adjusting over the spine. So even if the records played a part in that, if he had looked at the records and based on that misinformation he chose to adjust in that place, the injury is still caused by the defendant physically adjusting over the plaintiff's spine, as opposed to the records themselves. So there is no contradiction between what the plaintiff's expert testified in our case for punitive damages. And the law in Arizona is that even in medical malpractice cases, that expert testimony on the possibility of causation is sufficient to meet the plaintiff's burden if there is other evidence that suggests a causal relationship. And like I said, in this case, in addition to the testimony that this causal link was possible, and the plaintiff's expert identifying these breaches of the standard of care with respect to record keeping, it was also that he looked at the records immediately before making this mistake that caused injury, and that the mistake in the records is the same as the mistake that caused injury. So based on that evidence, the jury could have reached the conclusion that there was a causal relationship, even if the court found that a medical expert is required, which plaintiff does not believe that it is. Moving on to a second issue with respect to the court precluding the plaintiff's expert from testifying about the pattern of negligence in the records. The law is clear that previous examples of misconduct can in fact serve as the basis for punitive damages if they have a reasonable relationship to the state of mind that occurred at the time of injury. There are many examples in case law of conduct going back even 15 years, like in the Hawkins case, where the court based the punitive damages award partly on evidence of the defendant's actions 15 years prior, which plainly did not cause any injury to the plaintiff. Accordingly, it was a mistake for the court to rule that any evidence of a pattern or practice of negligence with respect to the records was inadmissible. And then moving on to the third issue with respect to exclusion of financial information. The fact that the defendant was putting all of his patients at risk regularly in order to enrich himself can serve as the basis for finding that there was an evil mind to justify punitive damages. So in this case, the defendant sort of implied at trial that he had no choice but to not keep actual records because it was too time-consuming and there was no way that he could do that while staying in business. But if the financial information showed that he was actually making money hand over fist while he was ignoring all these ethical violations, then that indicates that he was in fact risking his patient's safety in order to enrich himself. Moving on to a further issue with respect to the exclusion of Alan Botnick as a witness. Plaintiff acknowledges that he was disclosed a month after the deadline, but he was disclosed before the trial date was set, almost a year and a half before the trial actually took place. So in this case, there was no actual prejudice that was suffered to the defendant. And so in that case, I think exclusion of the witness was an unwarranted sanction. And with respect to the final issue, with respect to the motion for summary judgment on the second independent malpractice claim based on errors in the records. This sort of highlights the first issue with respect to if the court finds that we can proceed to retry the claim on punitive damages without deciding this issue, then it does not need to decide this issue. But if it finds that the motion for summary judgment ruling precluded our claim for punitive damages, then we would ask the court to review this issue. And basically, we believe that because the plaintiff's expert testified that a causal link was possible combined with the other evidence, we met the causation burden to proceed. So if there are no further questions, I'll reserve the rest of my time.
Thank you, counsel. Mr. Martin.
May it please the court, my name is Kevin Meyer from the firm of Broning, Oberg, Woods & Wilson. With me is Robert Sullivan, and we represent Dr. Grant. Claim for personal injury is about what causes the injury. And there's a mechanism that causes the injury, and if there is additional conduct that also contributes causally to the injury, that constitutes an intentional or willful disregard of a substantial risk of harm, that type of conduct can be penalized by punitive damages. But to be clear, punitive damages focuses on conduct, and the conduct has to have a causal relationship to the actual injury that we're talking about, that's at the center of the plaintiff's individual case. With respect to Saucedo, Saucedo states on page 184, paragraph 19, the conduct giving rise to punitive damages must be a proximate cause of the harm inflicted. The Hudgens case at paragraph 38 states, this complained of conduct must have proximately caused harm to the claimant to constitute a basis for punitive damages. And that was the missing link in this case. Plaintiff's own expert, Dr. Friedman, refused to give an opinion to a reasonable degree of medical certainty that the documentation issues actually were causally related to the injury, which was the maladjustment over the rods. And without that evidence, without that causal link, punitive damages were properly withheld from the jury.
Isn't the jury allowed to draw an inference from the fact that the physician is looking at a record that is arguably completely inaccurate as it relates to this patient and basing treatment decisions on that record? Isn't that reckless?
I don't think so, Your Honor, with respect to the fact that there had been 64 prior treatments of this patient successfully. This was not an instance in which a chiropractor took a hasty history and had inaccurate documents and didn't actually look at a situation and just made an adjustment recklessly.
Are you trying to suggest that the stock objective section that is populated in every one of these records is somehow accurate for this particular visit?
I think as Dr. Grant was getting used to his software, he was trying to figure out what the best use of it was. And the idea was that the information entered initially, early on, was consistent and was correct. And then the information thereafter was essentially would be populated anew, but would be filler. But there would be still the original record that would be easily accessible and would be available. And also, the x-rays were available. And this is not a situation in which records or information was not gathered or was not obtained.
Well, conceitedly, we aren't the jury. But isn't a jury allowed to draw an inference from this evidence?
Not in a medical malpractice case without medical testimony as to causation. And there was not that causation in this case. And plaintiff keeps making the argument that causation isn't really necessary because the jury could just sort of make that inference. But if a lay jury was capable of making the inference, then certainly a trained doctor could have opined that there was a reasonable degree of medical probability that this had an effect. But he couldn't, and he didn't, and he refused on more than a couple of occasions. And that was the reason for the trial court's ruling to keep the punitive damages out of the jury's hands.
So what was the difference then between the denial of the motion for summary judgment in the pretrial stage and the motion at the close of plaintiff's case?
I think it was essentially hearing the same information in a different light by the trial judge that was going to try the case. And based on that, the issue of causation was clearly challenged. It was set forth. And then after plaintiff's case was presented, at the end of that, we moved to exclude the punitive damages. And based on what had been presented, but because of the causation deficiency, punitive damages were kept out. This is not a new standard that we're seeking to impose. We're not looking for a new expert causation requirement in all cases. We're simply saying that if your case is medical malpractice and you're talking about the fact that something contributed to an injury, most lay people are not going to understand how that would have happened, and you need the medical causation connection through expert testimony, and that was what was lacking in this case. And that's the reason why the trial court excluded the punitive damages from the jury. So it's not a heightened standard. It's not something special to this case, and it can't be filled in through just the assumption of the juries, because again, if they could have, then certainly the doctor himself could have opined on the issue and would have clarified that it was medically probable.
So if we assume that the records the doctor is looking at when he is treating the patient, if we assume that they're inaccurate, our jury couldn't draw an inference that caused the injury without expert testimony?
So the question is, could the jury draw that inference without expert testimony? No, I think in this case, that was the struggle that Dr. Friedman had, that he couldn't say that simply because there were issues with the documentation, that was the reason that there was an adjustment over the rods. Again, this is not a patient that Dr. Grant was unfamiliar with. It was a patient that Dr. Grant knew and normally had been working on the right shoulder. And in this one instance, it worked on the left shoulder. So I don't think that's an inference that can be made. And again, if Dr. Friedman could have, he would have, I think. Plaintiff tries to say that there's a relaxed standard for this and that he just has to show that there's some possibility because of a sort of a heightened standard as long as there's other evidence of causation. And this is really what he argued to the trial court, which we argued the Thompson versus Sun City cases. But again, that's as the trial court rightly pointed out, that's an apples and orange comparison. In the, Thompson versus Sun City, you had an individual who was brought to a hospital who was clearly injured at the time, and then that hospital made a decision to try to transfer the patient. And the question was, to what degree did the transfer of the patient actually contribute or enhance the injuries? And again, since there was already an injury, it didn't have to be the cause, but there had to be some sort of causal relationship. In this case, plaintiff seems to be saying two things. It's the adjustment that caused the injury, or it's the bad records that caused the adjustment to be in the wrong place, which caused the injuries. But if that's the case, then there should be a causal link, and he should be able to prove that. As far as the other issues go, we believe that they all fall and stand on the punitive damage ruling. The financial records aren't necessary if punitive damages are not going to be shown. The expert exclusion was clearly within the trial court's discretion, and there was no reason for that. As far as the treatise goes, that was actually shown, or that was actually admitted at trial, and plaintiff was able to ask a question on that point, and so there is no error there either. But ultimately it comes down to the motion for judgment as a matter of law on the punitive damage and the summary judgment on the issue of negligence based on causation. And we think the trial court was correct in both cases. Unless there are any further questions.
Thank you, counsel. Mr. Weeks.
Thank you. I think it's important to look at the purpose of medical experts in testifying as to causation. Medical experts are there because they have particular knowledge to explain the physical mechanism of injury. Again, the plaintiff is not contending that the errors in the medical records were the physical mechanism of injury. It's an issue of what had happened in the defendant's past that may have caused his state of mind to make this mistake at the time of causing injury. And so to ask a medical expert to look back and say, what was it that the defendant had done prior to this that had caused him to make this mistake, is asking to have the expert give an opinion on the defendant's state of mind that caused injury, which is inappropriate. The law is clear that experts are not allowed to offer testimony as to the defendant's state of mind at the time of causing injury. And again, the plaintiff is not alleging that the errors in the records were the direct cause of the injury, but that it shows a pattern of practice of him recklessly exposing the plaintiff to risk. And the exact type of harm that was risked by that conduct is the harm that ended up occurring. So I know that the defendant had just quoted from the case of Saucedo. And as I mentioned previously, there are isolated quotes from both Forker and Saucedo that support the defendant's position when viewed in isolation. But there are other quotes from those cases that show the defendant's position to be incorrect. So quoting from Saucedo, it says, "The requisite intent and outrageous and egregious conduct must occur in tandem with the conduct giving rise to the injury in order to recover punitive damages. The conduct occurring in tandem with the conduct that causes injury presupposes that it's two separate things." And the case Forker, in Forker, the court says that after occurring conduct can be admitted if it has a reasonable relationship to the state of mind of the tortfeasor at the time of the event itself. So if conduct from after the injury can be used to support punitive damages, then plainly the conduct does not have to be the cause of injury in order to support punitive damages. And finally, the issue with respect to a causal link, the defendant's or the plaintiff's expert testified that causation was in fact possible. But a medical expert is not going to feel comfortable going beyond testifying what the physical cause of injury was and guessing as to what was going on in the defendant's mind that caused him to make this mistake. I think most medical experts would feel it was inappropriate for them to cross that boundary and start giving opinions as to why the defendant made a certain mistake or not, as opposed to what actually physically caused the injury.
Just so we're clear, your expert testified that, in his opinion, Dr. Grant improperly manipulated the patient over these titanium rods, and that was a departure from the standard of care and that it caused injury.
Correct. And he had also identified in his report that the various other failures to adequately document her condition were also breaches of the standard of care. And he testified that it was in fact possible that those errors in the records were what had led to him making this mistake that caused injury. And because the law in Arizona says that possibility of causation plus other evidence that could suggest a causal relationship is sufficient, even if the court were to find that expert testimony were required, we have met that burden. And finally, just to sum up, the defendant argues that it's not asking for like a new take on the law here. But the fact is the defendant has failed to produce a single case from either this jurisdiction or any other jurisdiction where a medical expert was required to establish the basis for punitive damages. In fact, the Court of Appeals just ruled last year in the case of Newman versus Select Hospitals. That was a case where the court decided that the punitive damage claim should have gone to the jury. And in that case, it said that even in medical malpractice cases, punitive damages are based on general principles of negligence. There is no heightened standard for punitive damages in medical malpractice cases. And in that case, it sent the punitive damages issue to the jury without any discussion whatsoever of a medical expert being necessary. Thank you. I have nothing further unless there's additional questions.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.